I'm Adam Winkler. I'm a professor of law at UCLA School of Law here in Los Angeles and the author of Gunfight, the battle of the right to bear arms in America. Well, I wrote this book for two reasons. One, at the heart of this book is the story of an amazing lawsuit known as District of Columbia against Heller, a Supreme Court case. It was the very first time, remarkably, that the Supreme Court had occasion to clarify the meaning of the Second Amendment. It had long been ambiguous what the meaning of the Second Amendment was. And this was the first time that the court was going to really make clear that the Second Amendment protected an individual right to bear arms. And that story was a great story. The litigation was brought by not by the NRA or any of the major gun rights organizations, but by a trio of libertarian lawyers led by a young lawyer named Alan Gura, a 30-something lawyer who had never taken a case to the Supreme Court. In fact, had never even argued a case at the Court of Appeals before this case. And the NRA fought him at every turn. So here you had this young rookie lawyer, inspired by his philosophical leanings towards libertarianism, promoting a view of the Second Amendment that you think the NRA would be eager to adopt, but instead they sought to scuttle this lawsuit at every turn. So it had great drama to it, that story. But the second reason was that in my research over guns, I found so many fascinating and surprising stories about the ways in which our efforts to balance gun rights with gun control have shaped profoundly our nation in so many unexpected ways. From the KKK, which began as a gun control organization, to the Wild West, which had the most restrictive gun control laws in the nation, to the NRA itself, which used to promote gun laws that today that same organization seeks to invalidate. So, District of Columbia against Heller, like I said, it was the first time the Supreme Court clarified what the meaning of the Second Amendment was and clarified that it protected an individual right to bear arms. The case involved a lawsuit over a ban on handguns in the District of Columbia. This ban on handguns had been in effect since 1976, but the NRA was not challenging it. It was a good law on the books. Um, it wasn't a terribly effective law, as many people know. Washington, D.C. in the 1980s, burdened especially by the crack epidemic, became the murder capital of the nation. So this law was in effect, and in 2001, when President George Bush was elected, his Attorney General, John Ashcroft, sent a letter to the NRA saying, hey, the administration has changed the official position of the executive branch. We now interpret the Second Amendment to protect an individual right to bear arms, unrelated to militia service. And that really inspired this trio of libertarian lawyers to bring a lawsuit against the District of Columbia, which had the most onerous gun control law in the nation. So they thought it would be a wise strategic choice to target that particular law. Well, the position was stark in this sense. So for decades, the federal courts had interpreted the Second Amendment to protect a right only associated with state militia service, and had very little relevance for ordinary gun control laws. And the executive branch, even under Presidents Reagan and others, hadn't really challenged that point of view for pragmatic reasons. They hadn't challenged the view because those gun control laws that were on the books were being used to put away criminals, especially in the war on drugs. So for law and order presidents, even the conservative presidents of the past, there was no need for them to articulate a new view of the Second Amendment or perhaps an old view of the Second Amendment. But the Bush administration came in with a lot of strong support from the NRA. The NRA was the biggest outside independent financer of the Bush the Bush election campaign in 2000, and obviously had a lot of support by the gun rights movement. So this was seen at the time as just sort of an effort to suggest to the gun rights community that we are on your side. What happened, however, is because of that position that they took, that position paper that the Attorney General John Ashcroft took, inspired drug dealers, gangbangers, anyone accused of a gun crime to bring challenges to their criminal conviction on the basis of the Second Amendment. These libertarians said, hey, we don't want the next big Second Amendment case to go up to the Supreme Court to be United States against crackhead. That's not going to be a great vehicle for reinvigorating the Second Amendment. So they went out and recruited strategically, like the NAACP had done in the Civil Rights Movement. Really good plaintiffs to target a really egregious law in a way that might warrant the justices' sympathy rather than their anger. we we often refer to it as a ban on handguns, but it was actually even more than that. It banned civilians from owning handguns, with certain exceptions for security personnel and whatnot, but also heavily restricted long guns, rifles, and shotguns. It said that if you owned a rifle or a shotgun, you had to keep it locked or disassembled, and you were only allowed to unlock it or assemble it for specified recreational reasons, such as hunting or target shooting. The thing was, in the District of Columbia, there was no place to hunt. There's no lawful hunting areas in the District of Columbia. And there's no places you can shoot a shotgun or a rifle. You need a special kind of long range, firing range to be able to shoot them. And so there was no such range available to civilians. So effectively, if you lived in the District of Columbia, you couldn't use your firearm for anything. And there was an early court ruling that suggested that if there was a burglar coming into your house and you had a rifle that was lawfully owned, properly registered, and disassembled the way the law required, you were not even allowed to assemble that rifle and use it in self-defense inside your own home. So effectively, Washington, D.C.'s law was a ban on the use of any firearm for personal self-defense, long gun or handgun. Dick Heller was a security guard in a federal courthouse in Washington D.C. who, during the day, was required to have a sidearm to protect the judges in the courthouse that he was in. When he went home at night, he had to leave his gun at work and not have the protection of a firearm. Heller lived in a bad part of Washington, D.C., where there was a lot of crime, and Heller thought that he really wanted a firearm for his own personal self-protection. So he was one of about 6 plaintiffs who were recruited by this trio of libertarian lawyers led by Alan Gura to bring this lawsuit against the District of Columbia. Thank you very much for having me.